Although U.S. immigration laws are complex and at times confusing, certain issues are quite clear. If you are a foreign national hoping to extend or amend your non-immigrant status in the United States, the failure to maintain valid non-immigrant status will result in dire consequences for you, including automatic cancellation of your visa, permanent ineligibility to apply for a new U.S. visa in any country except at the U.S. Embassy or consulate in your country of citizenship or residence, the accrual of unlawful presence, and a 3-year ban on re-entry to the United States where you have accrued more than 180 days, but less than 365 days of unlawful presence, or a 10-year bar on re-entry to the United States where you have accrued 365 days or more of unlawful presence. Moreover, foreign nationals who have failed to maintain their non-immigrant status are not eligible to change status, extend status, or adjust status to lawful permanent resident, and are also subject to removal proceedings, which means being deported from the United States. In this video, we hope to provide some guidance on which documents are essential to controlling one's lawful status in the United States, and what to do if you find that you have failed to maintain your lawful non-immigrant status. For most foreign nationals who are admitted to the United States in employment-based classifications, including but not limited to O1A, O1B, H1B, L1A, and L1B, there are 2 important documents that you must be aware of: Form I-94, Arrival Departure Record, and Form I-797, Notice of Action Approval Notice. While both of these documents are critically important and often contain similar information, they are confusing, as one determines the period of authorized or legal stay in the United States, and the other determines the period of employment authorization. While the information contained in these documents should coincide, at times the details contained in the documents can conflict, and this is where you can fail to maintain your status, either by overstaying the period of authorized stay as determined by the Form I-94, or working beyond the period of employment authorization listed on the Form I-797. Here's what's important for you to understand. Authorization to remain in the United States is controlled by Form I-94. A foreign national is issued a new Form I-94 upon each entry to the United States, and may secure their Form I-94 through U.S. Customs and Border Protection at the link listed in the description. Authorization to work in the United States in O1A, O1B, H1B, L1A, and L1B, for instance, is controlled by Form I-797, which is issued by U.S. Citizenship and Immigration Services upon approval of a Form I-129 petition filed by the U.S. employer. A foreign national may only work during the validity dates listed on the Form I-797 and may only work for the petitioner listed on the Form I-797. While the information on the Form I-94 and I-797 should coincide, we have found instances where the Form I-94s are issued with errors that have resulted in our clients failing to maintain status. Often, these errors occur when foreign nationals return from trips abroad and are issued new Form I-94s. It is imperative that you print and review the Form I-94 and provide a copy to your attorney upon each entry to the United States. Given the hectic nature of admissions at U.S. ports of entry and airports, there are numerous opportunities for the Form I-94 to contain errors in the class of admission, which determines whether you may work in the United States, and the admit until date, which is the expiration of the Form I-94 or the authorized period of admission. Recently, the immigration group at Minor & Landis has been successful in resolving maintenance of status issues for 2 foreign national clients who were present in the United States in H-1B status. While their personal details have been changed to protect their confidentiality, we are providing here the details that led to the failure to maintain their lawful non-immigrant status, which occurred through no fault of their own. Case Study 1. John Smith. John Smith is a citizen of the United Kingdom and possessed of Form I-797, the approval notice, for H-1B status valid until November 11, 2021. John traveled home to visit family and returned to the United States on August 1, 2019. Upon his entry, instead of issuing a Form I-94 with a validity period until November 11, 2021, CBP admitted Mr. Smith until March 1, 2020, which was the expiration date of his United Kingdom passport. Generally speaking, CBP will admit a foreign national until the expiration date of their I-797, approval notice, or passport, whichever date is earlier. This is critical to remember, as this happens with significant frequency. Mr. Smith, a frequent international traveler, had never experienced any negative immigration issues before and forgot to print, review, and send a copy of his I-94 to his immigration counsel. On November 1st, 2020, Mr. Smith contacted our office very concerned as he realized, while preparing to travel abroad to visit his family once again, that his I-94 had expired on March 1st, 2020, and that he had accrued 245 days of unlawful presence. If he left the United States, he would be subject to the 3-year bar on re-entry. Jane Doe, a citizen of Canada, possessed a Form I-797 approval notice for H-1B status valid until September 30th, 2019. Being first admitted in H-1B status on October 2016. Upon her last 2 entries to the United States from Canada, one in January of 2019 and the other in May of 2019, CBP issued a Form I-94 to Ms. Doe with an expiration period of September 30th, 2021, which was 2 years beyond the expiration date of her Form I-797 approval notice. Ms. Doe continued to work in the United States from September 30th, 2019, when her I-797 approval notice expired, until November 1st, 2020, when her employer contacted our office to start an employment-based green card petition for her. During the process of reviewing the employer's requirements, Ms. Doe's education and experience qualifications, and Ms. Doe's immigration history, we determined that she had been out of status from October 1st, 2019 to November 1st, 2020, more than 365 days. If she left the United States, she would be subject to the 10-year bar on re-entry. In these 2 cases, both Mr. Smith and Ms. Doe faced dire immigration consequences for failing to maintain their non-immigrant status. Usually, USCIS regulations prohibit individuals who have failed to maintain their status from filing untimely petitions to extend their status. However, under a provision of law, USCIS, in its discretion, may grant relief through a petition for nunc-pro-tunc, or retroactive extension of status. In order to qualify for nunc-pro-tunc extension of status, it must be shown that 1. The delay was due to extraordinary circumstances beyond the control of the foreign national or petitioner, and that USCIS finds the delay commensurate with the circumstances. 2. The foreign national has not otherwise violated their non-immigrant status. 3. The foreign national remains a bona fide non-immigrant. And 4. The foreign national is not the subject of deportation proceedings or removal proceedings. So what was the outcome? Minor and Landis successfully filed a nunc-pro-tunc extension of status petition on behalf of Mr. Smith and Ms. Doe, which USCIS approved retroactively, placing both clients back in lawful non-immigrant status and effectively erasing any periods of unlawful presence. These are just 2 examples detailing how a foreign national may fail to maintain their non-immigrant status, and how Minor and Landis was able to successfully assist our clients in resolving this dire situation and restoring their lawful status. If you find that you have failed to maintain your lawful status, please contact Minor and Landis for a consultation to determine how we may be able to assist you in resolving your immigration issues. Call us at 973-624-2400 to schedule a consultation now, or visit our website www.minor.com for more information.